This course is designed to teach you how to write an adjudication application or adjudication response submission for a security of payment claim. It is expected that you already have a good understanding of the security of payment process, timelines, and formalities. If you want to understand the security of payment process, please see the Introduction to Security of Payment course applicable for your state, available on the Security of Payment Submission Writer website. After this course, you'll be able to write a security of payment submission or other security of payment documents with the understanding of what the document is for and what it is trying to do. Given security of payment is a document-based system, it is through good documentation that you will get the result you want. The security of payment process has been set up in most states and territories in Australia through legislation enacted by the various state parliaments. The benefit of the security of payment process is that it allows for a quick and cheap method of getting paid for work done. It uses an adjudication process where the qualified and experienced adjudicator will provide a written determination with reasons regarding the liability to pay a claim based usually on the documentation alone. It is for this reason that your written documentation must be well produced and complete. This flowchart gives an overview of the security of payment process. Essentially, you need an agreement to undertake work or provide goods. Once provided, you may make a claim for payment. If the claim is not paid, then you may move to adjudication under the security of payment legislation. There are four main documents in the security of payment process: the payment claim, which is the request for payment; the payment schedule, which is the other side's response to the payment claim and states how much they are willing to pay and the reasons they are only paying that amount, unless of course they agree to pay the full amount. If the claimant is not happy, then they can go to adjudication and submit an adjudication application and submission. If a payment schedule has been served, then the other side may submit an adjudication response. The adjudicator will then make a decision called a determination, which includes the reasons for their decision. This determination essentially has the force of a court order. Security of payment is a process where information is given by way of documentation. Normally, this is written documentation, but it may include photos, images, audio and video recordings, and third-party documents. As you are trying to convince a person you will never see to make a decision in your favour, you must provide two things in your documentation: the reason or logic of your view, in other words your argument, and then support this reason with independent evidence, which will normally be appended or referenced documentation. All good businesses have set procedures for capturing and keeping information. Without proper process, your business is unlikely to flourish for long and definitely will not reach its maximum potential. This is especially true with cash management, of which security of payment is a part. In order to use security of payment as an effective tool to get quick and timely payment, you must ensure you collect the information needed and have it stored in a way which makes retrieval simple and easy. Information administration / management is a whole subject in itself, which can be broken down into specialties such as contract administration, OH&S reporting, and administration and financial records. Whilst a detailed examination of information management is beyond the scope of this course, there are some questions you should consider, which are now on the screen. In the security of payment process, there are three key players: the applicant, the respondent, and the adjudicator. When you are preparing a submission, you should be focused on the needs of the adjudicator. Unlike the previous two mentioned, the adjudicator has no prior knowledge of the parties, the relationship between the parties, how the parties have acted, or what the parties have said or communicated to each other. Nor is the adjudicator even interested unless it has a direct bearing on the matter under dispute. The adjudicator is bound by the Act, so the only matter under dispute is the payment claim that has not been paid at all or in part. As the adjudicator essentially only knows what the party tells the adjudicator, if you do not mention a point or matter, the adjudicator cannot infer it for you. Also, the adjudicator must be able to understand what you are arguing and why you are asking for whatever you are asking for. They must also be convinced by your argument, so keep it clear, concise, logical, and to the point, whilst ensuring statements are supported by evidence. It is often a good idea to get someone who does not have knowledge of the dispute to read through your submission prior to lodging to ensure your submission is understandable. Just because you understand it doesn't mean someone else who does not have your background in the matter. For example, in one application, the builder referred to several conversations with a Mr. K, who had requested the builder to do some additional work even though the contract was between Ms. K and Ms. B. The builder did not explain who Mr. K was, but the way the information was presented suggested that he had made a mistake in his submission and meant to put Ms. K. This made the submission difficult to read and confusing. It was only later in the respondent's submission that it became clear Mr. K was Ms. K's father. If that information had not come, the builder would have got a very different result. The builder should have said who Mr. K was. A submission is made up of two parts: the arguments supporting the claim and the evidence which corroborates the facts upon which the arguments lie. Evidence is what you convince or use to convince the adjudicator that your position is correct. For example, if you have claimed a 20% builder's margin on work done in your payment claim, your argument might be that clause 14 of the contract allows you to claim a 20% builder's margin on work done. Your evidence would be the attached copy of the duly signed contract to which you would refer the adjudicator to clause 14. Not all evidence is regarded as being of the same value or strength. For example, an audio recording of a meeting where you claimed the respondent agreed to the additional work you are now claiming payment for would be more persuasive than a note in your diary of the meeting. Evidence does not always prove something absolutely, but indicates that what you are saying is more likely true than not. An example would be if you claim something was agreed orally and the respondent says they didn't agree. This would be a classic he said, she said, and by itself of little evidential value. If you have sent the respondent an email soon after the alleged meeting summarizing what the parties had said or agreed to, and the respondent had never refuted your email even though it is not absolute proof that your claim is true, the adjudicator would be more inclined to believe you than the respondent. Your evidence should also be the best available and verifiable. So if you have an oral recording of a meeting, you would submit that rather than make a transcript of the recording and submit that instead. If you wanted to submit a transcript because the oral recording has a lot of background noise and it is difficult to hear, you would also submit the oral recording so the adjudicator can compare the transcript with the actual recording if they want. When relying upon any evidence, ask yourself, what am I trying to prove or convince the adjudicator of? Does this evidence support my argument or not? Also, do not include evidence where it is not needed. If you have a signed variation agreement that clearly shows you are entitled to charge $5,000, there would be no point submitting file notes of the meeting in which the variation document was signed, unless it specifically addressed another argument raised by the respondent. so make sure your evidence is as per the last points on the screen. Generally, your evidence should automatically be collected through your normal business processes. Occasionally, you may need to generate additional documentation as evidence, such as a more detailed invoice from a supplier than you would normally get, or take written statements from witnesses or photos showing disputed work. But generally, this should be the exception rather than the rule. The payment claim is the document that starts the security payment process. When you send the payment claim out, you should understand why you have claimed the amount you've claimed, how that amount is calculated, and what evidence you will rely on to prove your claim. If this is not the case, then you do not really know why you are entitled to make the claim. From a legislative perspective, the claim must identify the person liable for the payment, identify what work or goods the payment relates to and how the payment amount has been calculated. It must have a statement that it is a payment claim issued under the Security of Payment Act, which is appropriate in your state. To have a legitimate claim to be paid, you need to show two things. One, you have to have done the thing you are claiming payment for. And two, you have to ask for the amount you are entitled to. In regards to the amount claimed, you have to show you have calculated it in accordance with the agreement and law, and you have claimed it in the manner agreed and according to law. The applicable law here is the Security of Payment Act, relevant to your state. To assist in ensuring you have captured all the information you require to initially explain your claim, you can use a table as shown here. Firstly, you need to describe the work done for which you are making a claim. How you express the work will depend much on the nature of the job and the contract or agreement for the work. You can define the work by reference to a plan, a quote, a contract, or a description of the work, such as a 2-metre high wooden paling fence of 30 metres length. If a contract allows for progress payments, then you would refer to the description given in the contract, such as framing stage. The description needs to be clear enough for the person receiving the claim to understand what they are being asked to pay for. The next bit of information is the amount being asked for, which is a dollar amount and straightforward. Next, you need to explain how this has been calculated, and this is where many people often make an error. If the amount was for a set amount, then you would state the amount is as per the agreement by the parties, or if it was a progress payment, you might put as per amount stated for framing stage. Sometimes the contract will have a procedure that must be followed before a claim may be made, such as the claim needs to be submitted to a superintendent who has 7 days to assess the claim and issue a certificate for the amount payable. If there is such a process, you are required to adhere to it. Then you need to reference this. So for the example given, you might put amount as approved under section whatever of the contract by the superintendent. If the calculation is a complex one, then you need to reference a document that exists and explains it, such as a costing report. The question to ask yourself is, can a person using your explanation verify the amount claimed as being correct? With complex claims, this does not mean you have to show every detail of a calculation, only the process you have followed. Being able to show how you have calculated your claim is very important, because if you cannot explain how you have arrived at a figure, how can you argue that the figure is correct? The last component is noting the evidence you are relying upon to prove your calculation is correct. This may be a quote, a contract, timesheets, or such. We will now look at an actual claim. In this example of setting out your claim, the parties have a written agreement for the refurbishment of a bathroom for the amount of $6,000. Detailed specifications and plans are attached to the agreement. The work has been completed and the builder is claiming for the work done. The work done is claimed as a refurbishment of bathroom as per agreed plan. The amount claimed is $6,000. It has been calculated as the set amount is agreed in accordance with the contract, and the evidence that the builder is relying upon for this claim is the contract. In this example, the client has requested the builder to build a fence. It is orally agreed that the builder will charge cost price plus 20% for the materials and $60 per hour per worker. An oral estimate was given of 2 workers for 8 hours. The builder has detailed the claim by work done, fencing materials, 1,200, and it's been calculated of cost of material $1,000 plus 20%. The evidence is the invoice materials and some work diary notes. The second component is constructing the fence. The amount claimed is $960. It's been calculated by 2 workers at 8 hours at $60 per hour. The evidence is work diary and timesheets, the total being $2,160. Some of the most common errors people make with payment claims is failing to meet statutory timelines, failure to provide evidence of timeline compliance, miscalculating the statutory timelines. One of the timelines being, for example, the reference date, the date on which you're entitled to send out the payment claim, whether it be under the contract or whether it be under the Act. Failing to demonstrate entitlement to debt from contract to payment claim in logical step-by-step fashion. Failure to show how the debt has been calculated, and failure to show that the respondent is the liable party. The payment schedule is the client responding to your claim for payment. It is the respondent explaining why they will or will not pay what you are claiming and the reasons for their stance. When sending a payment schedule, the respondent must address the 4 points now shown on the screen. Must identify the payment claim it is responding to, must indicate the amount to be paid, if any. If less than the amount claimed, then must state the reasons for payment and can only raise those reasons in future proceedings, except in Victoria. So what do you have to do with a payment schedule if you are served? You have to examine it and be prepared to answer all arguments the respondent has raised. It is useful to use a table such as now shown to critically examine a payment schedule. If you use this process, you will be in an excellent position to defend your claim and be prepared to write your adjudication submission if needed. The table is self-explanatory and using it will save you time and money. First, the amount claimed is either the full amount of the payment claim, or if you have listed several amounts which together make up the total payment claim amount, then the subtotal amount the client has specifically identified for non-payment. Next, it is the amount the client is prepared to pay, which may be nil. You then need to understand why they are not paying and note that down. We will be looking at the reasons for not paying soon. You then need to state briefly, using dot points if necessary, why the client's reason is not valid. For example, if the client says you have not completed part of the work claimed, you would need to explain why this is not correct if you have done the work, or if it is true, why non-completion of that part of the work does not allow the client not to pay the amount claimed. Once you have stated your counter-argument, you need to identify what evidence supports your reasoning. Looking at the fencing example again, in this sample you have sent your payment claim and the client has sent back a payment schedule where they have argued they are not liable for the full amount of the payment claim. You have identified the two arguments that only $900 of the wood was used in the project and that one worker left the site early and that the agreed rate was $50 per hour, not $60. Looking at the table, we have the claimed amount, $1,200. What they are prepared to pay, $1,080. Only $900 of wood was used to build the fence. Your response is, the client requested we leave the excess material with them. Your evidence to this is a diary note. Your amount claimed of $960. They are only prepared to pay $750. Their reason, one worker left an hour early and the agreed rate was $50 per hour. Your response is, the worker who left an hour earlier continued to work through his lunch hour and the agreed rate was our standard $60 per hour. Your evidence could be a diary note, or in this case is a diary note, worksheet, and website if, for example, you have your standard $60 per hour mentioned on your website. Whenever considering any payment schedule, there are essentially only three types of argument that can be put for not paying. The first, that the goods or services claimed were not provided. Secondly, that the goods or services were not in accordance with the agreement. And third, the amount claimed is not in accord with the agreement. With our fencing example, the first argument was that only $900 of materials were used. This is a reason one argument. The second point had two parts. First was that the number of hours for labour claimed were not provided. This is a reason one type argument. And second, the agreed rate was $50, not $60. This is a reason three type argument. It is worthwhile getting out old payment schedules and having a look at the arguments given for non-payment and classifying each argument into one of these three reasons. This will increase your ability to identify arguments for non-payment and effectively respond. Before examining how to write a payment schedule, we need to look at some specific situations which might arise. The first is variations. Variations are the biggest area of conflict, and generally it is because variations are not properly documented. There are two areas of contention. One is something a variation to a contract or part of the original scope. The second is the cost. Often work is done without an agreed cost or an agreed method of costing a variation. To prevent these issues arising, all you need to do is to put the variation in writing, both the work to be done and how it is to be costed. In situations where a variation cannot be quoted at a set amount, then agree on a method for calculating the cost. It is a good idea to ensure your contract has a method in it for calculating the cost of a variation where there is no previous agreed cost. In the security of payment process, if there is not agreed cost or method for calculating the cost of work done, the adjudicator is required to follow a process as set out in the security of payment legislation. Often this process is not helpful and significant differences in the figure determined can occur depending on who is doing the calculating. It is recommended that you read the applicable Security of Payment Act for your business. Where there is agreement for work to be done, but the amount or a process for the calculation of the amount has not been agreed, the courts have traditionally relied on the legal concept of quantum meritum, which we will go into later. Quantum merit is a Latin phrase meaning as much as is deserved. Sometimes the court will take a slightly different approach where the court will imply a term to the contract saying that work done would be charged at a reasonable price. In the law of contracts, a doctrine by which the law infers a promise to pay a reasonable amount for labour and materials furnished in the absence of a legally enforceable agreement as to cost. Quantum merit prevents the other party becoming unjustly enriched. Quantum merit can be used to address situations where no contract exists or where a contract exists but for some reason is unenforceable. Courts imply a contract to avoid an unjust result. Quantum merit also describes a method used to determine the amount owed to a person by determining how much the defendant has benefited from the transaction or how much the plaintiff is expended in materials and services. Naturally, when you are running a business, you need to know what you are going to be paid for work done. The only way you can be assured of this is to have written agreements as to the work to be done and the amount you are to be paid. If the scope of works is to change, then put that change in writing and state what the cost is. You will save yourself a lot of time and money. Defects is another area where there is a lot of confusion. Many people do not understand the difference between a defect and failing to provide what has been contracted for. Thankfully, most standard contracts deal with this issue and define what a defect is and what happens when there is a defect. Normally, a defect is a minor matter which does not significantly impact on the client's use of the product. So a scratch on a kitchen benchtop would generally be a defect which would not entitle the client to refuse to pay a progress payment. Often clients believe they are entitled to withhold all or some of a final payment on a bill due to defects. Unless the contract specifically entitles them to do so, a defect is not a valid reason for non-payment. Generally, a builder has a period of time to rectify a defect. If, however, you are claiming for the progress payment due on completion of framing and you have only dug the foundations, the lack of framing is not a defect but a failure to do the work for which you are trying to claim. At times the distinction will be fine, but usually the guidance and definitions in a standard contract will suffice to determine which category a situation will fall into. With defects, it is essential to understand your contract and ensure defects are properly covered. Also ensure your clients understand the difference. Again, you can save yourself a lot of time and money if you understand how the contract deals with defects and ensures your client also understands. Damages arise from one party breaching a term of the contract and is a remedy provided at law for the person who suffers a loss. Damages are awarded by a court through its judicial power. When awarding damages, a court has assessed the situation and determined one party should pay the other a specific sum of money because it has done something it should not have done or failed to do something it should have done. An adjudicator is only concerned with the one payment claimant, not necessarily the entire obligations under the contract. An adjudicator has no judicial power and makes a determination under the security of payment legislation. An adjudicator therefore does not have the judicial power required to award damages. Under some contracts, if a party fails to do something, then they agree to pay the other party something. For example, if the builder does not finish the building by a specific date, then they agree to pay a certain amount of money for each day the building is overdue. If this is a term of the contract and one of the parties relies upon this term, then an adjudicator can take this contractual arrangement into account, but only in so much as it is possible in relation to the payment claim in adjudication. For example, if a builder has run overtime by 3 months and so is required under the contract to pay, say, $5,000 to the client, the adjudicator may take that $5,000 into account when determining the matter in regards to the payment claim. If the payment claim is for $12,000, then the adjudicator may offset the $5,000, saying only $7,000 is due and payable. If the payment claim is for $4,000, then the adjudicator cannot say that the builder has to pay the client $1,000. The adjudicator can only say that the client does not have to pay the payment claim of $4,000 as it is offset to nil. The reason for this is the adjudicator is only determining the liability of the client to pay the payment claim. So the adjudicator cannot award damages, but a contractual right to a specific sum of money may be used to offset the payment claim liability, but only to the maximum of the payment claim amount. This now leads us to consider the concept of offsetting. The right to offset is another area where parties tend to be confused as to how it works. Firstly, offset is the right to offset money owed to you by the party against money payable by you to that party. It is not an automatic right. Unless a proven debt, it may be difficult to rely upon it in adjudication. If you want to use offsetting, you should provide for it in the contract. So like damages, unless there is a contractual entitlement, an adjudicator cannot offset amount owed by the client to the respondent. Writing a security payment submission is made easier if you remember there are 2 grounds for claiming payment and only 3 grounds for refusing to pay. Defects, damages, and offsetting are not grounds for refusal to pay a payment claim under the security payment process unless the contract specifically allows for them. Returning now to the payment schedule. When writing a payment schedule, you use the payment claim as your reference point. It is important to remember when writing a payment schedule that you are only advising if you are going to pay the payment claim in full or in part, and if not in full, why. You are only responding to that particular claim, not to what you are unhappy about regarding the builder's actions or service in general. This means you may have a valid complaint or claim against the builder, but unless the claim is going to legally reduce your obligation to pay that particular payment claim, it is irrelevant and generally should not be raised. As with the payment claim, it is helpful to lay the information out in a table as shown on the screen. Doing this will make writing your payment schedule and, if necessary, adjudication response much easier, saving time and money. You are also more likely to get the outcome you are seeking. As mentioned before, there are only 3 types of reasons for not paying. 1. The goods or services claimed have not been provided. 2. The goods or services claimed have not been provided in accordance with the agreement, or 3. The amount claimed is not in accord with the agreement. These 3 reasons go to your liability to pay the payment claim amount. Issues of damages, defects, and offset have already been dealt with and are not reasons for not paying. Instead, they go to your right to reduce the amount you are liable to pay. In other words, you are liable to pay the claimed amount for work done as requested by the builder, but are entitled to a credit to reduce the amount because of things owed to you by the claimant. But as said, this right to reduce must be within the contract. It is important to understand the difference, as people often confuse the reason why they are not required to pay and so fail to provide a proper reason or evidence to support their argument. As you are only allowed to raise arguments in adjudication that have been raised in the payment schedule, except in Victoria, if you do not properly understand the basis of your arguments, you may accidentally exclude some vital points. If you follow the table, methods such an occurrence is unlikely. First, list the amount the other side is claiming. If the payment claim has itemised amounts, some of which you reject, you can list those, otherwise you may just list the total amount of the claim. Next, state what you are prepared to pay, followed by a calculation as to how you arrived at that figure. You must be able to show how you have arrived at the figure, otherwise how can you explain it to the adjudicator? Next, state the reason for not paying the difference between what is being claimed and what you are prepared to pay. Next, you list the evidence you rely upon to support your reasoning. Looking at the fencing example again, as a respondent, you are claiming that whilst the builder purchased $1,000 worth of materials, he only used $900 worth on your job. The rest of the material was damaged by the builder and dumped on the site rather than being taken away by the builder. You took photos of the damaged material and have a written statement from a neighbour who says he saw the workmen damage some of the timber when they unloaded it. The same neighbour also saw one of the workers leave an hour early, and you, as a respondent, claimed, when discussing costs with the builder, he said it was $50 per hour, not $60. The payment claim lists the amount for materials and labour separately, so you can easily reference the itemised amounts. You can now put this information into the payment schedule table. When writing up your payment schedule, it is perfectly alright to include the table as part of your explanation. If you have overpaid this builder $50 on a previous job and the builder said you could use that credit on this job, you would list this separate to the above table as it is not a reason for non-payment. You obviously can use it to reduce. You agree you are liable to pay, but you are claiming you have already paid $50 as evidenced by the credit note. The same is true if you are claiming amounts payable to you under the contract, such as when a builder has not completed in time and the contract required the builder to pay a daily amount to the client. Again, in such instances, you would list them separately in your payment schedule because you are not claiming you do not have to pay. You are saying you are paying the payment claim amount by way of set-off. In each case, explain what you are claiming and how you have calculated and the evidence you rely upon. Some common errors with payment schedules: again, failing to meet statutory timelines, such as the time you have to have the payment schedule served on the builder, failure to provide evidence of timeline compliance, miscalculating statutory timelines, failing to demonstrate a reason for non-payment in a logical step-by-step fashion, failure to provide supporting evidence, failure to serve a payment schedule, failure to actively participate in the security of payment process. If a matter goes to adjudication, there are some additional matters that need to be addressed which are not part of the payment claim or schedule. Interest and costs of the adjudication are two of these matters. Generally, under security payment legislation, interest is payable on payment claims from when they are due and payable and remain unpaid. Interest is calculated according to the contract or the security of payment legislation. You should be aware of the specific provisions of your contract and the security of payment legislation in this matter. Often, a generic statement in the submission or response will suffice. This is dealt in more detail later in the course. Whilst it is expected you already understand the security of payment and legislative requirements, we draw your attention to the importance of the reference date and ensuring your contract states when you are entitled to make a claim for payment and when that claimant has to be paid. If the contract is silent, then such dates will be determined by the legislation. Judicial arguments generally will only be raised by the respondent. Essentially, all a jurisdictional argument is that the claimant has not the right to have the payment claim adjudicated. Jurisdictional arguments have no bearing on whether the respondent is liable to pay the claimed amount or not, only if the security of payment process is available for this claim. For example, if the contract is not a construction contract as defined by the Security of Payment Act, then the matter cannot be adjudicated under the security of payment process. If a procedural timeline has not been met, such as the time allowed to lodge an adjudication application, then again, there is not possible to use the security of payment process. If you are going to use a jurisdictional argument, you need to ensure you mention this in your payment schedule to alert the claimant that there could be no benefit in continuing with the security payment process. Raising a jurisdictional argument rarely offers a benefit to the other party except to increase costs and delay resolution of the matter. Often it is when a lawyer is employed to draft a payment schedule or adjudication response that jurisdictional arguments are put, as the intention of the lawyer is to defeat the application or process rather than resolution of the dispute in many cases. Even when successful with a jurisdictional argument, the claimant will usually only have to reissue under security of payment or through the courts, and the respondent has gained no advantage. Indeed, the respondent may be even more out of pocket. Even so, it is important to ensure you comply with the security of payment process. It is not a difficult process, and compliance is easy with proper attention to the timelines. We will now turn to actually writing an adjudication application. Any adjudication application has three parts: the application form, the written submissions, and the supporting attachments. We will now deal with each of these parts in turn. The application form is the document you fill out with your submission and attachments. This form is the formal request to start the adjudication process and is lodged with the nominating authority like Adjudicate Today. Essentially, you are required to supply your details as claimant, the details of the person or entity you are claiming from as respondent, and details about the contract which forms the basis of the dispute. Whilst there is no prescribed form and it does differ from state to state and from nominating authority to nominating authority, the security of payment submission writer will automatically generate an appropriate adjudication application form for you in response to your questions. The written submission is the crux of the application and may be divided into the sections as set out on the screen. These include stating the claim, dealing with any jurisdictional issues, giving the background and history of the matter, detailing your claim, listing points in dispute, responding to each point in dispute, advising your calculation of the reference date and any submission on interest, and dealing with costs. We will now look at each section of the submission in turn. This section states the claim and has the purpose of setting the scene for the adjudicator. In one paragraph, it defines the current situation and subject matter of the dispute. The statement on the screen can be used as a pro forma to start any adjudication application submission where you just insert the requested information. As you can read, it identifies the payment claim being adjudicated and the amount of the claim. It also advises if a payment schedule has been served, and if so, what has been agreed to be paid, and if that amount has indeed been paid at the time of making the application. If you use Security of Payment Submission Writer, this section is dealt for you automatically. The next section concerns jurisdiction, and arguments against jurisdiction are only raised by the respondent, because if the applicant believed there was no jurisdiction, they would not be making an application. It is worthwhile, though, setting out your adherence to the security of payment process, but advising that the claim relates to a contract covered by the Act. A valid payment claim was served in accordance with the contract and security of payment legislation, that a payment schedule was or was not received in response. If no response, that the required notice was sent to the respondent of intention to apply for adjudication. That there was or was not a payment schedule served in response to that notice, and the application has been lodged in accordance with the Security of Payment Act. Whilst this section is optional, it is considered best practice to include it, and it makes it easier for the adjudicator to follow your application. As the name suggests, this section gives the backgrounds to the payment claim. Remember, it is the payment claim being adjudicated only, so keep information relevant. Keep brief and to the point. The purpose is to set the scene for the adjudicator, to advise how and when the commercial agreement formed, to give a brief timeline of activity and interactions, up to the issuing of the payment claim or schedule notices under the security payment legislation and your application. Detailing your claim. This is what you are asking for, so make sure you explain what you want, how you have calculated it, and why you are entitled to it. Even where there is no payment schedule or the respondent is only disputing one or two items of a claim, you still need to show the adjudicator you are entitled to the entire amount claimed. This is where your payment claim table you developed to write your payment claim can be used. It is acceptable to insert the information in a table format. Remember, the adjudication is only about the one payment claim, and you need to show you are entitled to be paid the amount of that claim. It is important you explain what the claim is for and how you have calculated the amount. and why you are entitled to the payment now. You need to reference the terms of the contract and legislation. Points in dispute. Once you have detailed and explained your payment claim, you have to deal with any specific points the respondent has raised. You may feel you have already addressed them in the previous section when you explained your entire payment claim. Even if this is the case, you need to still specifically address each point the respondent has raised. Naturally, if there is no payment schedule, you do not need this section in your submission. If you have followed the advice given earlier of using a table to analyze the payment schedule, you can use that as the basis of this section, or you can cut and paste that table into this section. If you do not want to do this, then use any format you want, making sure you identify all the points in dispute. You get these points from the payment schedule, set them out as dot points or table. If no payment schedule, state that the respondent has failed to serve a payment schedule and therefore may not raise any issues in dispute. Remember to respond to each point. Address each point for non-payment in turn. Remember, there are only 3 legitimate reasons for non-payment. State why the point is incorrect. This will normally be a way of asserting a fact. Support this fact by referencing evidence. If no independent evidence, the adjudicator will often look at the behaviour of the parties. Remember to respond to each point. Address each point for non-payment in turn. Remember, there are only 3 legitimate reasons for non-payment. State why the point is incorrect. This will normally be a way of asserting a fact. Support this fact by referencing evidence. If no independent evidence, the adjudicator will often look at the behaviour of the parties. After you have addressed each point raised in argument by the respondent, you need to put in this section what the reference date is and how you have calculated it, and request interest be payable from that date on the unpaid portion at the rate set by the contract or security of payment legislation. If you do not include this section, you may find the adjudicator does not include interest in the determination, making it more difficult to collect. In this section, you ask for costs to be awarded against the other party. Again, if you do not ask for costs, the adjudicator may not include it in his determination, and you may have to pay costs you could avoid. It is recommended you use headings for each section. The cost section is the closing section of the submission. You do not need to use any form of words to end the submission. It is satisfactory to just finish the written part of the submission with a request for costs. It is useful, however, to have an index page listing the attachments at the end of the written submission. If you use Security of Payment Submission Writer, this will be done for you. The attachments forms the final part of the application and contains the documents, plans, audio recordings or such that you have referred to in the course of your written submission. Each document or item should be given an attachment reference such as A, B or 1, 2, and once you have put the whole application together, each page or folder, if holding a CD or such, needs to be numerically numbered. This includes the attachments. This then allows you to refer not only to a specific attachment but to a page within the attachment. This is very useful if the attachment is a large document. For example, attachment A may have 30 pages. You could either number the pages of each attachment numerically, continuously for all attachments, or start back at 1 for each new attachment. Whatever method you use, you should be able to direct the adjudicator to the very part of an attachment you want, such as attachment B, page 20. Doing this makes it easier for the adjudicator to follow your submission. Where possible in your submission, when we refer to a specific part of an attachment, such as a clause in a contract, it is recommended to quote the exact verbatim in the body of the submission. This again allows for the adjudicator to more readily follow your submission without having to flick between pages. Once you have written your submission, use this checklist to ensure you have covered everything. It is also recommended that you get someone to read over the application to ensure it reads in a coherent and logical fashion. While spelling and grammar are important, do not fuss too much about this. Clarity and ease of following your submission are more important. The checklist is available in the Document Helper Kit for the adjudication application, downloadable from the Security of Payment Submission Writer website. Writing an adjudication response. Like the application, the response can be divided into three parts: the response form, the written submission, and the attachments. The adjudication response form is very similar to the application form, so I would refer you to the comments made in regards to the adjudication application form. The written submission for the adjudication response follows the set out of the application submission essentially, and you are referred back to those two screens. The main difference is that your arguments will be directed to why you do not need to pay. Quickly going over each section, you have stating the claim. You then have jurisdictional issues, where you put any jurisdictional arguments you may have. You give a brief background and history of the matter. If you accept the statement as in the adjudication application, you can just reference that. You detail the claim, list points in dispute, and respond to each point, putting your arguments. Generally, there will be no arguments to put in regards to reference date unless you disagree with the applicant. In regards to interest and costs, unless you have a specific argument you want to put on those points, then generally you would not need to specifically address them in the submission. Once you have completed your adjudication response, go through this checklist to ensure you have included all vital and essential information. A copy of the checklist is available in the Document Helper Kit for the adjudication response, available as a download to subscribers of the Security of Payment Submission Writer website. Congratulations, you have now completed the How to Write Your Security Payment Submission. This course is a resource for you, and you can access it and refresh yourself on any aspect. You now should be able to know how to write an adjudication application response, how to keep your work files to facilitate using the security payment process, know what an adjudicator is looking for, know what evidence you need to back up your claims, know the importance of documentation in the security payment process, and know how to write and use payment claims and payment schedules. If you want further help, you may reference the Security of Payment submissionwriter.com, which offers information, training and subscription service where you can automatically have your subscriptions written for you. All you need to do is answer some questions and bingo, you have a completed application or response.